Yes.
Maybe allowed to mention item 20 of the edition with this technology. Here you wrote, I need to receive instructions. So I know about sometime to receive instructions. Lordship, this is with regard to that traffic music case
Okay.
that was already disposed and my lord was telling the opposite party that they bringing instruction or affidavit will not change the position of law.
Mm.
And I'm covered by para 18
Mm.
4.
Mm.
Para 18 surplus 4.
Mm.
Where it says recovery in cases where an employee has wrongfully been required to discharge duties of a higher post
Mm.
and has been paid accordingly,
Mm.
even though he should have rightfully been required to work against the inferior post. This also is below my status because I was given officiating promotion since 2007.
Mm.
We were given 2007 to in between 2007 and 2013.
Mm.
And after more than some 16 years, now they are asking to recover the officiating promotion to the post of SDO salary to be recovered.
Mm.
Because they have stated that we have been superseded.
Mm.
Lordship, that is our case.
Mm.
So when the law is very clear, Lordship,
Mm.
and this has been listed this twice because my lordship was of the opinion that it should be disposed of as covered by this case.
Can you obtain verbal instruction? Can you obtain verbal instruction from the respondent authorities? We'll take it up after some time at 12 o'clock or at 2 o'clock, no problem. Because the law is well settled. In that case, why should we keep the matter pending in the court?
Your lordship here, since the notice has already been issued and on top of that, your lordship, the representation is still pending, so lordship, and the recovery has not been made.
Okay, you dispose of the representation, relying upon the decision.
Yes, if that's the case, for disposable of representation, I have no objection.
Yes, madam.
If it's for disposal.
But keeping in mind, they will dispose of the representation, keeping in mind the paragraph number 18 of the Rafiq Masjid case. That will serve your purpose.
I just hope and pray that I won't come back to this honorable court again.
Okay.
Since there is a settled law, lordship,
Mm.
settled law
Mm.
that can override the representation also if we go by your lordship.
Mm.
She can bring instruction like the other day. That
Mm.
is the same. The principle of law applies, lordship. The other day that was also
Okay.
disposed of
Okay.
as per the notification of the respondent government.
Okay.
The principle of law applies. Even the
You
notification.
try.
Yeah, if that's
Will
the
I
case,
take it up at 12 o'clock
tomorrow then.
tomorrow? Tomorrow?
Lordship,
Okay. Tomorrow.
verbal instruction.
Okay. On the appeal being made by Ms. Ina Oli, learned government advocate, with consent from the other side, the matter is then adjourned to be listed by tomorrow, so as to enable her to obtain instruction from the respondent authorities.
Oh,
At least my lord.
Mm.
Lordship, I'd like to mention item number 10.
Mm.
I've taken the concern of the other party.
Mm.
Maybe we list after 2 weeks for filing affidavit.
Mr. Angami, learned government advocate. You are as senior government advocate? Senior government advocate. Any objection, madam? With consent from the other side, first for listing the matter after
3
3
weeks.
weeks after fair allowed. Yeah,
Like to mention item number 21 for hearing.
21.
Yes, Lord. The thing from the party, this may be fixed on the 5th of February, Lordship.
5th of February.
Lordship.
Mr. Mao Zamir, learned counsel for the petitioner with consent from the other side, press for listing the matter on 5th of February. Pair allowed.
Right, item number 11 in the court. In this case, Lordship, I have already received the payment, Lordship, which may be allowed to withdraw, Lordship.
Withdraw. Okay. Heard Mr. Zamir, learned counsel for the petitioner and madam. Learned is the government advocate for the state respondent. Mr. Zamir submits that the petitioners in both the petitions have received the payment,
Lordship.
and as such, there remains nothing to be decided in this petition, and the same may be closed. Accordingly, taking note of the submission of learned counsel for both the parties, the matter stands closed.
Lordship. Pleasure.
Lordship, I beg to mention item number 3. The estate is yet to file for the age of. I beg to mention 3 weeks time to file that.
Yes,
Options.
Ms. Sunso, learned government advocate, with consent from the other side, press for listing the matter after 3 weeks. After 3 weeks, pair allowed.
May I please your lordship?
My lord, I beg to mention item number 8. My lord, get the receive instruction, and my lord, I've taken consent from the opposite party, so it's depending on which should expect.
Mr.
80 per home for the state council.
Learned counsel, no, learned government advocate for the respondent,
Resolution number 5, 6, and 7.
5, 6, and 7, with consent from the other side, press for listing the matter after.
Yes,
The last opportunity, Lordship.
After
3 weeks.
The last chance, Lordship.
after 3 weeks. Mr. Zamir, learned counsel for the petitioner, however, submits that the last opportunity may be given to the respondents to file their counter affidavit. Accordingly, taking note of the submission of learned counsel for both the parties, last opportunity is afforded to the respondent number 5, 6, and 7
Yes.
to file their counter affidavit. In the event of failing to file counter affidavit before the next step, the court will proceed to hear and dispose of this petition without the on the basis of materials available on the record. You have for respondent number
1 4.
1 to 4. Okay.
Worship, we have panel.
You have filed.
They have just already filed.
Alright.
May I please your lordship?
Yes.
I beg to mention item number 4, lordship. I am for respondent number 4, lordship. I may be given 3 weeks time to file my affidavit in opposition, lordship.
Your good name, please.
Apila Sanktam.
Miss Apila Sanctum, learned government advocate,
No, lordship. Private.
learned counsel for the respondent number 5.
4, lordship.
Sorry, respondent number 4 submits that the matter may be listed after
3 weeks, lordship.
3 weeks, so as to enable her to file counter affidavit.
Lordship.
Miss learned counsel for the petitioner submits that. Any objection? That she has no objection. Miss S. Sang, learned government advocate for the respondent number 1 to 3. 1 to 3 present.
Oblige, lordship.
After 3 weeks. Okay.
Oblige, lordship.
Please, your lordship, I beg to mention having what did you do, lordship? Can you give us a little time for the additional affidavit?
22. You will file additional affidavit.
Yes.
Ms. So-and-so, learned counsel for the petitioner, submits that she will file additional affidavit in this matter, and she may be granted
1 week time.
1 week time. 1 week time. The pair having not been opposed by Ms. Sang, learned government advocate, stands allowed to raise the matter after 1 week.
Yeah, please, your lordship. Lordship, I beg to mention item number 9, lordship. Item on behalf of my colleague, and your lordship. But this matter can be listed after 3 weeks, lordship.
Ms. Sang, learned counsel, appearing on behalf of Mr.
M. Nomar.
N. Langkumar, learned government advocate, with consent from the other side. Any objection?
No, your lordship, the reason bereavement.
Okay.
Okay.
With consent.
Only
from
the
the-
interim order may come.
Okay. Press for listing the matter after
After 3 weeks.
after 3 weeks, pair allowed. Press shall list the matter after 3 weeks. Interim order pass earlier shall continue.
Worship, I have similar prayer for item 13. Worship. Here are making the six drafts, but so, and we should 3 weeks time, Worship.
Ms. Sung, learned government advocate. With consent from the other side, tries for listing the matter after 3 weeks as she has not received any instruction from the respondent authorities. We are allowed recess and list the matter after 3 weeks.
Worship, I have similar prayer for item 14. On behalf of M. November.
Yes, Madam, you have a petitioner. Okay. Ms. So-and-so, learned counsel, appearing on behalf of Mr. So-and-so, learned government advocate, with consent from the other side, press for listing the matter after 3 weeks.
3 weeks.
After 3 weeks, pair allowed.
Worship, I have similar prayer for item 15. Worship.
15. Yes, any objection? Similar order? Yes,
Worship, I quickly mention item 24. Worship. On the option item 11. If this medical listed after 3 weeks, Worship.
on behalf of
M. November.
Ms. Sun, learned government advocate, appearing on behalf of Mr. N. Lankumar, learned government advocate. Any objection? With consent from the other side, press for listing the matter after 3 weeks. After pair allowed. Interim order pass earlier shall continue. Recess shall list the matter after 3 weeks.
Much of it.
I picked to mention hearing item 25. I feel that the mirror will become after 2 weeks.
Mr. Walling, learned counsel for the petitioner. You will, any objection?
No.
With consent from the other side, press for listing the matter after 3 weeks. After 3. Pair allowed.
Next topic.
Hmm.
Item 5. On for the petitioner. I've received the evidence filed by the respondents. I may be given a 3 weeks time to find reply.
Heard Mr. Prosecutor Patel, learned counsel for the petitioner. And Miss
General for the state.
learned government advocate for the state respondent. Any private respondents are there? You have a private respondent number? Four. Mr. Patel, learned counsel for the petitioner, submits that he will file a reply to the counter affidavit filed by respondent number,
What respondents? State itself the private respondents.
filed by all the respondents, and he may be granted
3 weeks, Lordship.
3 weeks time. Pair allowed. Recess and list the matter after 3 weeks.
I have
Lordship, I beg to mention item 7. If it can kindly be fixed on 19th of February for admission deadline.
19th.
Yes, ma'am.
Mr. Shanti Younger, learned counsel for the petitioner. Any objection?
No, Lordship, it's a consistent prayer.
Okay. Mr. Younger, learned counsel for the petitioner, and Mr. Mauzamir, learned counsel for the respondent, jointly write for listing the matter on 19th of February. Pair allowed. Recess and list the matter on 19th of February. Interim order passed earlier shall continue.
Lordship, I also would like to mention item 18. Lordship, the matter has now become in fluxus. As such, we wish to close the case matter because Lordship, the new fees has already been elected. And they have also been duly recognized by the Boxing Federation of India. I would like to place these 2 documents on record of each other report. It may kindly be marked as an X and Y, and get on the report of each other report and the measure that we closed.
Heard Mr. Shanti Younger, learned counsel for the petitioner, and Mr.
For
Learned counsel appearing on behalf of Mr. Younger Rati, learned CGSC. Mr. Shanti Younger, learned counsel for the petitioner, producing 2 documents. one notice dated 9/11/2025, and also one press release dated 9th of August 2025 submits that new office bearers have already been elected.
Yes, my lord.
Elected
New office bearer of the Napa.
office bearers of the
Association.
of
It has
the
already been duly recognized by the Boxing Federation of India.
Nagaland Amateur Boxing Association have already been elected, and as such, the matter become infructuous and the same may be closed. Accordingly, taking note of the submission of Mr. Santi Younger, learned counsel for the petitioner, the matter stands closed. The documents produced before this court today shall be marked as Annexure X and Y and be taken to the record.
It's low back. But if the individual may be vacated.
Interim order passed earlier stands vacated.
And be closed.
Mayor, Mr. Port. Lordship, I beg to mention item number 23 on behalf of my senior. What we learned citizen. If this matter can pending, we fix up the 1 week as my seniors in this post.
Okay. Mr. So learned counsel appearing on behalf of Mr. Yangarati, learned CGSC. With concern from the other side, press for listing the matter after
1 week.
1 week, as Mr. Yangarati is indisposed of. Fair allowed, rest shall list the matter after 1 week.
Let's know. Is your lordship. Lordship, I beg to mention item number 6, your lordship, for the solar membership. Lordship here.
Respondent number
3, your lordship.
3.
Lordship here where it. Lordship, if 2 weeks time be given to file our affidavit, your lordship. 3 weeks, your lordship.
Okay. Heard Miss Esther, learned counsel for the petitioner, and Mr.
And so, your lordship. on
Learned
both
counsel for the respondent number
3, your lordship.
Respondent number 3.
1.
1 and 2. And Mr. So learned additional lazy for the respondent number 1.
1.
1 and 2. 1 and 2. The learned counsel for the respondent number 3 submits that he may be granted
3 weeks time, your
3
lordship.
weeks time to file counter affidavit. Fair allowed, rest shall list the matter after 3 weeks.
So if there's an interim.
Interim order pass release shall continue.
Maybe it's lordship.
Yes.
Lordship, I think to mention item 16, lordship. And on behalf of the lordship, with few that we can see lordship, to find everything else.
Lordship.
Ms. Sang, learned counsel appearing on behalf of Mr.
Actually,
Learned counsel, learned government advocate, with consent from the other side, press for listing the matter after 3 weeks.
3 weeks,
Fair allowed.
much obliged.
For motion, item number 1.
It's on the days to compensate upon the motion. We other expired in the year 2019.
Hmm.
Now, they have submitted an application for appointment in terms of the office memorandum 17 September 2015.
Hmm.
There's a scheme which is formulated by the state government, which has reserved 50% of the vacancy arising in a year for compassionate appointment. Now, the deputy commissioner won lodgement, under which establishment my father was serving. He has already scrutinized my documents and it was forwarded to government for approval.
Hmm.
It was in the year 2022,
Hmm.
stating that I have fulfilled all the eligibility criteria as well in terms of the office memorandum.
Hmm.
Now again in the year 2024, the same deputy commissioner has also written to the government for the approval. It has also stated in the year 2024 that I'm pleased and serial number 1 of the list for compassionate appointment.
Hmm.
Despite of such recommendation by the concerned deputy commissioner, my case is yet to be considered, Lordship.
Hmm.
In the letter, if your Lordship, I highly appreciate in the year 2024, it has stated that there are altogether 24 vacancies, 17 vacancies available in the establishment. So against any of those vacancies, I may be accommodated. That is the recommendation made by the Deputy Commissioner. But despite of lapse for more than 7 years now, I'm here to be considered for appointment launching, which is why I'm before this honorable court.
Heard Mr. Mauzamri, learned counsel for the petitioner. And Madam Sang, learned government advocate for the state respondent. So, Madam, why the matter has not been approved? Why the proposal has not been approved?
That's right, that's right. So notice may be issued.
Can you obtain instruction by tomorrow, verbal instruction?
Lordship, this matter can be listed next week, Lordship.
Next week.
Lordship.
Only verbal instructions, so you can be listed tomorrow. Because the documents are very clear, Lordship.
No, if the Deputy Commissioner Mon has recommended the name of the petitioner twice, why the matter has not been approved by the government?
Right, direction can be issued to appoint against any of those vacancies available, Lordship.
Obtain instruction tomorrow?
Lordship.
In this petition under Article 226 of the Constitution of India, the petitioner has applied for issuing direction to the respondent authorities to consider the application filed by the petitioner on 30th 9/2019 for compassionate appointment in accordance with the law and the applicable policy. Mr. Zamir, learned counsel for the petitioner, submits that the father of the petitioner was serving as
Beyond, Lordship.
peon in the establishment of
Deputy Commissioner Moon.
Deputy Commissioner Mon, and he died in harness on 26/6/2019. Thereafter, the petitioner has filed an application for for being appointed on compassionate ground on 30th 9/2019. Thereafter, the competent authority has found the petitioner eligible under the applicable guidelines and thereafter recommended the name of the petitioner by letter dated 21/2/2022. Thereafter, again, the matter of the petitioner was forwarded to the government for approval by letter dated 7/9/2024. And the name of the petitioner was reflected at serial number 1 in the compassionate appointment list for appointment to the post of MTS within bracket grade 4. Mr. Zomi further submits that since the filing of the application on 30th 9/2019, the matter is pending for last 7 years and the respondent authorities have not been approving the name of the petitioner, though the competent authority has forwarded the same. Accordingly, taking note of the submission of learned counsel for the petitioner, Ms. Sang, learned government advocate, is directed to obtain instruction and to receive instruction from the respondent authorities and to place the same before this court tomorrow. This is the least the matter of time.
From the supplementary cost list for motion, item number 26.
May I please, your Lordship?
Yes.
Hello, petitioner is owning a plot of land which is touching the Kohima Mukokchung Road. That is National Highway number 2. And for the last 16 years, he has been developing the land with the hope that it will be utilized for some commercial purpose. And his primary objective was to apply for a petrol pump to put. And then sometime in 2015, the power grid, they have erected the towers. And then the cable passed through the high tension cables passed through the land of the petitioner. And then his initiative for opening a petrol pump, the technical survey came in 2019. And then there only he was informed that the petrol pump depot cannot be opened in a place where high tension cable are run overhead. So that's how his aim has been frustrated. Thereafter, again, petitioner wanted to raise his building because already there was some constructions, but then it cannot be raised further. So it is a commercial floor, and the land cannot be used for any other purposes in view of the passing through the cable wire of the high tension cables. So he submitted a representation to the power grid authorities for relocation of the towers to another place because he cannot use his land for any other purpose, which is a commercial area. Now, in sometime in 2021, 22, the power grid has replied to the representation of the petitioner saying that on security reason, this cannot be permitted. And no construction, no commercial activity can be done within a limited area, restricted area. So we were also instructed to vacate the area also. So those are the things. So I have submitted a representation in 2025 also in the month of October. On 28th of October, I submitted a representation that you relocate the post. Otherwise, you have to compensate me. You have to pay compensation for the land.
No. Whether before erection of the tower
Lordship.
and the line,
Yes.
no objection was obtained from you by the.
They have not, neither they have informed me, nor any objection, no NOC was obtained from any authority. And I was not aware.
Is
that,
it?
Yes. I was not aware that such a restriction will be there. Since all the constructions are done in the public interest, since it is a development project, I did not object it at that relevant point of time. Only after he communicated to me that this is not possible. And in the meantime, the Hindustan Petroleum Corporation also informed me that this cannot be possible when there is high tension cables, which is passing overhead.
Yes, anybody for respondent number 1 and 2, Power Grid Corporation?
No, Lordship.
No.
At this stage, Lordship, I have two options. One, Lordship may issue a direction to the authorities to dispose of a representation, which I have submitted on 28 October 2025.
Okay.
Or the second option is Lordship can issue notice and let them file counter. Thereafter, the matter can be decided.
The second option, let notice go at this is.
Lordship.
And for respondent number 3, Madam, you are appearing. Heard Mr. C.T. Zamir, Learned Senior Counsel, assisted by Mr.
Aliba Ozakam.
Learned Counsel for the petitioner, and Ms. Ina Holly, Learned Counsel for the respondent, Learned Government Advocate for the respondent number 3. In this petition under Article 226 of the Constitution of India, the petitioner has applied for issuing direction to the respondent authorities. More particularly, the respondent number 1 and 2.
Yes.
1 and 2. To divert the high tension line from the petitioner's land or to pay adequate compensation assessed by the independent valuer. Mr. Zamir, Learned Counsel for the petitioner, submits that the petitioner is a owner. The petitioner is an absolute owner of a plot of land situated at Kohima Zuneboto Y Junction under Ongma village of Mukoksan district for last 16 years. He has developed the land for establishing a fuel station, establishing the same as fuel station site, and also erected one commercial building. Then in the year 2015, the respondent number 1 and 2 have erected 220 kV DC Moriani Mokoksan transmission line within bracket LOC number 157-158 overhead the petitioner's plot of land without notice of use restriction under CEA Safety Regulation 2010. Mr. Zamir further submits that the petitioner, in public interest, did not object at that moment, since the petitioner was not aware of about the far-reaching consequence to be caused to the petitioner in long run. Thereafter, in the year 2019, Hindustan Petroleum Corporation has rejected the site of the petitioner after technical survey due to safety risks, fire, within bracket, fire, explosion, etc. from the lines over it. Thereafter, the petitioner, having received a remark from the Hindustan Petroleum, submitted one representation sometimes in the year 2020 to the respondent number 1 and 2, highlighting his grievance and requesting to divert the said transmission line away from the property of the petitioner. But the respondent authorities, by letter dated 23rd of August 2022, had instructed the petitioner to refrain from residing in or using his own commercial building and that the respondent authorities would not be as responsible for any accident that might occur due to transmission lines overhead. Mr. Zomi further submits that thereafter on 28/10/2025, the petitioner has filed one representation to the respondent authorities to resolve the long-standing grievance of the petitioner and his family, but the same failed to evoke any response. The submission of Mr. Jamir needs further consideration. At this stage, notice be issued to the respondent, returnable in 4 weeks. Step upon respondent number 1 and 2 be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 3 since Ms. Ina only entered appearance and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Please the matter after 4 weeks.
Lordship, the pendency of the writ petition may not be a bar for the respondent to consider the representation of.
Okay. It is being clarified that pendency of this writ petition would not be a bar in disposing of the representation filed by the petitioner on 28 on
28/10/2025.
28/10/2025.
Motion, item number 27.
petitioner is seeking appointment to a grade 4 post on the basis of land ownership, Lordship. Can we come to page 29? Annexure I, page 29. This is the letter by the medical officer forwarding the application of the petitioner. This is dated 22nd May 2025, which was addressed to the Principal Director, Directorate of Health and Family Welfare. And then down below, Lordship will find on the left-hand side, the date is also mentioned, 22nd May 2025, that is the date of forwarding the letter. And just below that, Lordship will find with a seal, a date, that is 24/11/2025. This is the seal of the Directorate of Health and Family Welfare, on which date they have received the forwarding letter, that is 24/11/2025. And before this date, before receipt of the forwarding letter, on 6th of August 2025, 2 months ahead of that, the Directorate has already forwarded the applications of the private respondent number 4 to the government. And then on 3rd of December 2025, the government has completed its approval. And on the next day, that is the 4th December 2025, the appointment order of respondent number 4 has been issued. So I have reasonable apprehension and suspicion that the application of the petitioner was not forwarded to the government for approval. Otherwise, because it transpires that the Directorate has received only on 24/11/2025, whereas it appears from the government approval letter, which is at page 27. It shows that this approval order has been conveyed in terms of a letter dated 6 August 2025, received from the Directorate. Therefore, these two documents clearly demonstrates that the application of the petitioner has not been considered. Now my question is, after receipt of the application on 24th November 2025, at least they could have taken some steps for consideration of the petitioner's application, but till date they have not taken any steps. So the petitioner is approaching this honorable court to consider his case for appointment on the basis of landowner. There is a clear government notification for consideration of the landowners on in grade 4 post. And the appointment, since the appointment of the respondent number 4 has been done without any selection process. So I'm bringing before this honorable court to stay the appointment of the private respondent number 4 and consider the case of the petitioner for appointment on the basis of land ownership. There was no selection process at all. And in case of landowners, the advertisement, in case of landowner appointment as well as compassionate appointment, government has issued a memorandum in 2022 that the advertisement has been exempted, dispensed with in case of landowner appointment and compassionate appointment. And the private respondent number 4 is not a landowner, and without any selection process, they have appointed the respondent number 4. Otherwise, if it is not landowner appointment and it is not compassionate appointment, then it could have been advertised. If at all they want to appoint any other person, but such selection process has not been conducted. So the appointment of the respondent number 4 is illegal in itself, so it has to be stayed off.
But without hearing the respondent number 4, would it be proper to grant any stay at this basis?
Then Lordship, we consider the stay on
Next
the
day.
next day.
Next date.
Lordship.
Let notice go at this is this.
Lordship.
Yes, madam. What is your submission?
Lordship, at this stage, let notice go.
Notice go.
Lordship.
And may I pray that Lordship may also call for the record of the government approval order, that file which is reflected in page 27. Otherwise, if there is delay, there is chances of again improving the process, Lordship. The file which is mentioned in the government approval letter, whether the case of the petitioner has been sent along with that. I don't think it will be possible because they have received only on 24th November 2025.
Heard Mr. City Zomi, learned senior counsel assisted by Mr. So learned counsel for the petitioner, and Ms. So learned government advocate for the state respondents.
123.
Number 123. This petition under Article 226 of the Constitution of India, the petitioner has right for setting aside and quashing the approval order dated 3/12/2025 of Srimati R. Kumzila. The respondent number 4. By the Undersecretary to the Government of Nagaland Health and Family Welfare Department, and also to set aside the impugned appointment order dated 4/12/2025 of Srimati R. Kumzila, respondent number 4, by the Principal Director, Directorate of Health and Family Welfare, Nagaland, and also to Director Respondents to consider the case of the petitioner and to appoint him on land ownership basis in terms of clause 3B of the notification dated 5/3/2018.
2018.
Yes. Mr.
5/3.
Zamir, learned counsel for the petitioner, submits that the petitioner is a landowner where the present community health center of Samator town, Nagaland, is established. And the said plot of land was donated free of cost on a verbal agreement between the landowner and the government to provide a grade 4 post on land ownership basis. And the landowners have not availed any appointment on land ownership basis till date. And the petitioner came to know that a vacancy arose owing to the retirement of one L. Somong Bhait, who was released by order dated 28/3/2025. And then the petitioner has submitted an application to the Principal Director, Directorate of Health and Family Welfare, Nagaland, Kohima, and to the Medical Officer, CHC, Samator, Nagaland. And both the letters dated 21/5/2025, seeking appointment on the basis of land ownership. And he has also a descendant of the landowner who has initially donated the land. While Mr. Zomir further submits that while the petitioner was awaiting for consideration of his candidature for being appointed on land ownership basis, the respondent authorities have appointed the private respondent number 4 without any advertisement or selection process. By appointment letter dated 4/12/2025 against the very vacant post which the present petitioner has claimed. Under such circumstances, Mr. Zomir submits that the appointment letter issued to the private respondent number 4 may be state, and the relevant file being file number page number 27,
Yes. First line,
file number
page 27.
HFWA within bracket capital APPT-8 stroke 124 stroke 2023 stroke 125 dated 5th of December 2025 may be called for from the respondent authorities.
Lordship, I beg your pardon, Lordship, the first line means the letter of the letter.
Yes.
Letter.
Yes. That is
Not
the
the
file
top.
number.
Sentence starts with, I am directed to refer to your letter number. Not the top one, but the
No,
body
no,
of the
this
letter.
is the memo number. This line.
Which is line is letter number THFW3 of 117, grade 4, stroke TSG, stroke 2018, stroke 3681, dated 6 August 2025.
No, that is the letter number. The file number would be perhaps this one. This fourth line.
Yes, Lordship, that will also be suffice. It will come automatic. Good. But the government letter and the government file and the directorate file will be different. The approval letter which Lordship has reflected is the government letter. So it will be the government file.
Yeah.
But the directorate has forwarded in a different file. So directorate file will be different. And we can ascertain from the directorate file.
The directorate file is this is letter, not the file number, perhaps. The number you have referred to.
Lordship.
This is letter number.
This will also suffice, Lordship. Yes, what Lordship has said is correct.
The learned government advocate submits that at this stage notice may be issued. Having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed on record. Let notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, 2, and 3, since Ms. So-and-so, learned government advocate, entered appearance and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Step upon respondent number 4 be taken by speed post and also by usual process within a week from today. Interim pair of the petitioner will be considered on next returnable date. In the meantime, the learned government advocate shall produce the relevant file number HFW, the one I have referred earlier, before this court on next date. List of top 4 weeks.
Motion, item number 28.
Your Lordship, I am appearing for the petitioner, my Lord, in item number 28, my Lord.
Yes.
My Lord, I am appearing for a life insurance company by the name of Tata AIA Life Insurance, based out of the zonal office in Calcutta, my Lord. My Lord, the insurance company received a death claim in the year 2025 from the respondent number 4 being the wife of the deceased victim as per an accident report, my Lord. My Lord, during the investigation of the claim process, several red flags were noticed by the internal claims investigation department, wherein despite it being presumptively an accidental death, my Lord, no postmortem was conducted. The first responder to the scene, which is Mr. Abdul Salem, being a stranger to both the respondent number 4 and 5, the deposition or the statement of Abdul Salem was not recorded. And my Lord, in a hurried manner, without going through the financial irregularities or the background, even the CCTV footage, the tower dump cluster. My lord, a final report for closure as an accident report was submitted, my lord. My lord, I would, my lord, invite my lord to page number 24, my lord, which is the FIR, my lord. And page number 25, 26 is the complaint that was filed by the brother of the victim, Mr. Atoba
No,
Zimon.
Mr. Counsel, you see, in this petition, you have prayed for reopening the investigation.
Reinvestigation of the
Yes.
complaint, my lord.
Under what provision the reinvestigation can be made? You are not audible. You
My
are
lord,
not audible.
my lord, am I audible, my lord?
Yes, now audible.
My lord, under section 194, I don't have a remedy to go before the learned magistrate for filing an arazi and asking for reinvestigation. My lord, because I am neither the relative kin of the victim, the de facto complainant, neither I am related, except for the fact of the matter that I am assessing a claim worth 2 crores. My lord, may kindly hear me for 2 minutes, my lord. My lord, when we received the claim, we, upon our investigation, internal investigation, we found certain discrepancies in relation to the financial transactions. My lord, the policy was taken on 4th June 2024. My lord, the policy was
No, Mr. Counsel, you tell me where is the closure report?
My lord, the closure report.
The same with this petition.
My lord, the closure report is at page 37, my lord.
37.
The final report, which was accepted by the learned Chief Judicial Magistrate, Parent, Nagaland, dated 13th March 2025, my lord. My lord, all of these documents were placed along with the death claim application by respondent number 4. And during the internal investigation of which, there were these red flags which was raised by our own claims investigating department. That is the reason we had filed a representation on 19th August 2025 post completion of our investigation with the local police station and as well as the superintendent of police at Perrin. My lord, that representation has not been considered till date. That is what has brought, my lord, asked to file this writ petition under 226 seeking a reinvestigation. If I am able to satisfy, my lord, regarding what are the points due to which the claim investigation process was delayed, stalled, or rather the red flags was raised, my lord. My lord, if I may, my lord, take my lord to page number 26. My lord, the initial complaint.
No, before accepting the closure report by the magistrate might have heard you.
No, my lord, I was not even in the scene. My
Okay.
lord, I am not connected. That is the reason, my lord, at that point of time, respondent number 4 and 5 were examined, and thereafter, on their declaration itself, the closure report was accepted and the investigation closed. FRT was granted, my lord. My lord, kindly take up the initial complaint which was filed, my lord. My lord, if I may read, my lord, with due respect, I have the honor to inform your good office that on 18 January 2025, at around 10:10 p.m., which is respondent number 4, informed me that on 18 January 2025 at noon, my brother, her husband, which is the victim, went to Perrin district for a business trip. And at around 10 p.m., she received a call from his husband's mobile number, and the caller is supposed to be a good Samaritan, informed her that the owner of this mobile phone has met at a car accident at below Old Jalukia village. Besides that, the caller told her that he and his friend, while returning back from Parent Town towards Dimapur, after dropping one passenger at Parent Town on the halfway at Old Jalukia area, they approached near her husband's car from behind. But suddenly his car was rolled down below the highway. Therefore, they stopped on the spot and went towards the spot of the fatal car for rescue, pulled out her injured husband, and shifted to Ain Nursing Home and Diagnostic Center, Jalukia town for medical aid, first aid later. Concerned doctor referred and advised them to take the patient immediately to Dimapur for good equipment facility hospital. As per the doctor advice, the two good Samaritan again took her to Dimapur and they are on their way. In the intervening time, she requested them to bring her husband at 4th Mile Central Jail Junction, but unfortunately her husband succumbed to the injured. We, the family members, are hereby request your authority to kindly investigate the matter from your end. My lord, this is on 18 January 2025. My lord, thereafter the FIR is lodged. My lord, may kindly take annexure C, which is on page number 28, my lord. My lord, for the inquest, they had to be taken to a government hospital for the postmortem to be conducted, and the circumstances for the investigation would be material, my lord. My lord, at 28, refusal for conducting post-mortem examination. My lord, this is being attested by the brother of the victim. I have the honor to state that the below noted deceased person who expired on 18th January 2025 at about 12 hours. My lord, kindly note this time. This time as it has got no reference, because in the earlier complaint and the FIR, the time which has been mentioned is at 10 p.m. on the way to Dimapur due to accident, and below may kindly be handed over since there is no suspicion of any foul play for the cause of his death. My lord, which is contrary to the earlier complaint wherein the brother of the victim, which is respondent number 5, is requesting the police to investigate the matter after lodging the complaint, my lord. My lord, may kindly take up page number 29. My lord, this is again a request for handover of the dead body. My lord, the dead body is definitely can be handed over only after post-mortem of, if it is an accidental death. My lord, there are catena of judgments that post-mortem is absolutely mandatory to investigate and come to a conclusion as to what is the cause of death, what has gone into the system, what went wrong with the victim that led to the accident or otherwise. My lord. My lord, secondly, page number 30, my lord. My lord, refusal of conducting post-mortem examination. This is again being attested by the respondent number 5, the brother of the victim. With due respect and humble submission, I have the honor to pray to your esteemed authority to kindly hand over the deceased body without conducting post-mortem, my lord. My lord, subsequently, my lord, which is at page number 31, my lord, respondent number 4, wife of the deceased victim, is affirming an affidavit before the first class magistrate Dimapur, Nagaland, my lord, wherein, my lord, fourth paragraph, that my aforesaid husband expired on 18 January 2025 at around 11 p.m. at Chokduma, Chomuku Kedima district, Nagaland, due to car accident for which competent authority has granted death certificate by such and such date. That after decease, the investigating agency tried to take the post-mortem, but out of respect towards the deceased, my lord, the request is from the family members not to conduct the post-mortem examination. And here, my lord, there is a statement that the investigating agency tried to make the post-mortem, and out of respect, they have stopped from conducting the post-mortem examination. My lord, these discrepancies are very glaring, because I come to the next statement, my lord, which is the accident information report. My lord, as per the report, which is at page 33, my lord,
Hmm.
my lord, the first paragraph itself, on 18 January 2025, at around 7:30, 19:30 hours. My lord, where does this time come from? Because the first call that was received by respondent number 4, as per the initial complaint of respondent number 5 being the brother of the victim, was at 10:10 p.m.
Hmm.
Subsequently, my lord, a telephonic information was received at PS Peren from one Abdul Salam. So
Hmm.
he is the first responder to the scene. He is a good Samaritan, my lord, who has basically recovered the victim. Even at that point of time, the victim was alive, and transported him to the nearest diagnostic center, which is in uh, nursing home and diagnostic center, wherein the doctors have stated that they don't have the medical facility to treat the victim, and hence they should take it to a appropriate government hospital. My lord, all this while the police is of the information that an accident has.
Mr. Counsel, you say this petition is filed by the Tata AIA Life Insurance Company Limited.
Yes, my lord.
What fundamental right is available to you to invoke the jurisdiction of
My,
under Article
my, my,
226?
my lord, my lord, my lord, I am a registered company under Section 3 of the Insurance Act, my lord. My lord, I also am regulated by the Insurance Regulatory Development Authority of India, and I have stated that in my third paragraph of the petition, my lord.
Hmm.
My lord, without which I could not transact any business, insurance business, in the territory of India, which is the central insurance transactory license, which is granted by IRDA, my lord. My lord, post the final report, the claim is being made. That is only when I am coming into the picture. My lord, the claim is made by respondent number 4, obviously being the wife of the victim. She has preferred the claim, being the nominee of the policy, under which the claim cover is 2 crore. My lord, may please note, it's a 2 crore claim. It's a high value claim. It is not as if it is a 10
Maybe
lakh claim.
we are not concerned with the value of the claim.
My lord, my lord, my lord, my lord, why
You first satisfy this court under which provision and under which law this court can direct further investigation of the parent PS case number 1 of 2025.
my lord, if my lord takes up section 194 of the BNSS, my lord,
Hmm.
my lord, it says that if there is any kind of discrepancy in the investigation, my lord, my lord, we are being connected through a contractual fiduciary relationship with the deceased victim by dint of the policy. My lord, when there are red flags in our investigation, we approach the police authorities for a reinvestigation under 194 of BNSS, 194, specifically 194(6). My lord, there we have pointed out that not only the postmortem, which actually discloses the cause of death or the physical state of the victim, which has led to either the presumptive accident or the foul play. My lord, if that is not ascertained, my lord, the processing of claim on our behalf gets question mark, because every report of claim process has to be forwarded to the IRDA, and the IRDA has to satisfy whether the claim has been fraudulently calculated, disbursed or not. My lord, we are effectively performing a public duty when it comes to processing any kind of death claim, my lord. My lord, secondly, my lord, if my lord comes to the representation that we have filed before the authority, which is at page number 43, my lord.
Hmm.
My lord, kindly note.
So, before filing this application, whether you have approached the a jurisdictional magistrate to conduct further inquiry?
My lord, that is what? My lord, the statutory power under 194(6), the
Hmm.
locus does not lie with us. Since there is no remedy, the alternative remedy would have been to come under 226, which we have done so, prior to which we have already made a representation to the police authorities and the state. My lord, I would like to point out from the representation, may kindly take up page number 43 of a representation. On 19th August 2025, we had filed this representation with the Additional Superintendent of Police, Parent District, Nagaland, my lord.
No, you tell me whether the superintendent of police can direct further investigation or reopening the case
My
after
lord,
the
my,
same closed
my
by
lord,
the sectional magistrate?
my lord, this was a representation. My lord, as per police does not have the power to reinvestigate until and unless there is an order from the magistrate. My lord, since my locus would be
No,
challenged,
now, do you want that this court should function as a magistrate court?
my lord, but if I cannot approach the magistrate under the law, the alternative remedy would be to be coming by way of a writ petition under 226, my lord.
I am not satisfied with your submission. We will list the matter on in the next week for hearing on the point of maintainability. You come prepared?
My lord, can it be posted in the week thereafter? Because I am coming from Calcutta, my lord. I will take a little bit of time to book my travel, my lord. If it is,
Okay. You suggested that then?
my lord, would it be possible to list the matter on 11th February, my lord?
Yes. 11 February, that is Wednesday.
Wednesday is usually the day.
So on that day, it will not be possible.
My lord, and then would it be possible on 12th February, my lord?
Okay, all right. Heard, Mr. Your good name, please.
My good name is Shorjo Mukherjee, my lord.
Shorjo Mukherjee, learned counsel for the petitioner, and also heard Miss
Yes, Mary.
learned
Government advocate.
government advocate for the state respondent. List the matter on 12/2/2026 for hearing on the point of maintainability.
Grateful, my lord.
For admission, item number 2.
Lordship. Lordship, here in the presenter, I'm the respondent number 1, state. And on going to the fact of the case, we have now filed affidavit in the opposition. We are just, my stand is rely on the annexure, the page number 50 of the repetition.
No, first,
G.
first let the counsel for the petitioner
I
start.
will be allowed to relieve the proceeding because I have some personal.
Okay. You are relying upon
Annexure G.
Annexure G.
Yeah, that is a decision given by the coordinated bench in the similar case. So my presence may be reflected. I may be allowed to relieve.
Annexure Z at page number?
Annexure G at page 50 of my petition. Annexure G, page 50 of my petition. What I'm saying, my lord, is that my petition is already covered by these cases.
Okay. Okay.
And the state is also in agreement with me. Basically, that's what
Okay.
the additional AG is stating.
Okay.
Yes.
Okay, all right.
Thank you, Lordship.
Yes.
My lord.
Mm.
So, my lord, there is a village called Yaztu village
Mm.
in the Kifri district,
Mm.
in the Kifri district of the state, Yaztu village.
Mm.
Now, this village was established sometime in 1878
Mm.
by tribesmen from the Sankam tribe and the Sema tribe,
Mm.
two tribes jointly. And when the village was established, the Sankam tribe had its own kell, the Sema tribe had its own kell. The Sankam tribe had its own GDs,
Mm.
chiefs.
Mm.
The Sema tribe had its own chief.
Mm.
So beginning from 1878, we, the petitioners,
Mm.
we are from the Sema tribe. The Sema tribe.
Mm.
We have had our own chiefs, and in the Sema tribe, chieftainship is hereditary.
Mm.
So the person who is chief now is in line with the person who first established the village and became chief from the Sema tribe.
Mm.
So we are in that line, beginning from 1878.
Mm.
Now the private respondents have their own narrative as far as the establishment of the village is concerned. They are claiming to be the founders of the village, effectively.
Mm.
And that is the dispute, in a nutshell.
Mm.
So I have my own narrative, the private respondents have their own narrative.
Mm.
So there is a factual dispute there as far as the chieftainship is concerned
Mm.
between the two sides. Now, in the year, Your Lordship, in the year 2004, Your Lordship, may kindly note, 1878, the village was established.
Mm.
My family has been in the line of chieftainship since then.
Mm.
In 2004, for the first time, the private respondents,
Mm.
that is the respondents 2 to 4.
Mm.
Lordship, during the pendency of the petition
Mm.
for the respondent number 2 expired.
Mm.
Now he is substituted by respondents at page 3. The Lordship considered at page 3. And for his 6 sons.
Mm.
And they are the respondents 2-1, 2-2, 2-3, 2-4, 2-5, and 2-6.
Mm.
At page 3 and 4, is the Lordship got that? Now, in the year 2004, claiming to be the persons who established the village, effectively, Lordship, the language is not in that line, but effectively that is what it means.
Mm.
Claiming to be the persons who established the village, they submitted in the application a complaint dated 28/1/2004, which is at page 23. Page 23.
Yes, Annexure B.
Yes, and it should be, and the English translation type copy is at page 24. Twenty-four is a typed copy,
Mm.
and 25 is a translated copy.
Mm.
Can we go to page 25, my lord? This is to the GB's court. Kindly know the language, my lord.
Mm.
To the GB's court and village council chairman of Yangzitong A and B village. So it is not addressed to the village council, it is to the GB's court.
Mm.
Kindly know that, my lord, to the GB's court. And the date is 28/1/2004, subject for deciding the dispute to the establishment of the village between Shoiho and Kukike. So Shoiho is the person who the private respondents derive from.
Mm.
They are his descendants. Kukike is my ancestor. From him, we descend, my lord.
Mm.
Firstly, my respect to the GB's court, and I request a settlement of the dispute between the descendants of the two forefathers as stated above. Again, look at the language, my lord. My respects to the GB's court, and I request the settlement of the dispute between the descendants of the two forefathers as stated above. Now, this GB's court is not a court contemplated by the rules. It is not a court, my lord. It is not a court. Notwithstanding the fact that it is not a court, it took up the matter, it passed a so-called settlement. And your lordship will find that at page.
It is not court.
It is not a court.
Then how can we exercise jurisdiction under Article 227?
That's precisely the point. I'm coming to that, man. I'm coming to that.
Mm.
I'm coming to that. So, this court, the so-called court, passed a settlement which is at page 26.
Mm.
And HSC. The last product. And the English translation is at page 31. At page 31.
Yes.
May I read, my lord?
Mm.
Translated copy office of the GB's board, Yangzitong A and B village. So
Mm.
A is the Sangtam Ken, B is the Sema Ken.
Mm.
The GB's Board of Yangtze-tong A and B Village on 28 January 2004, on examining the chieftainship dispute in Yangtze-tong B, has come to these findings. Since 10 witnesses have clearly stated that the grandfather Yangtze-tong told Shoy Ho to establish his own Asa Ken, and that no one would trouble him if he established his own Asa, therefore the Yangtze-tong A and GB's board decides that Shoy Ho's children will be the chiefs, heads of Yangtze-tong B village. So Shoy Ho, again, Your Lordship, is the ancestor of the respondents to the four, the private respondents. Now, the GB's court has come to the conclusion that based on the statements of witnesses, Shoy Ho is the one who established the village on the Sema side. Now, against this is not a court. I refuse to accept this. I wrote to the village council. I said, village council, you decide the matter. Now, village council is a court. Village council is a court, according to the rules. Now, Your Lordship will see, I wrote to the village council, and it should be at page 33.
Yes.
The typed copy is at page 34. Translated copy at page 35. Mm. 10/2/2004. To the council chairman of Yangtze-tong A and B village, non-acceptance of the decision of the head GB in the dispute between Kuike and Shoy Ho. With due respect to the above subject, it is stated as under the decision of the GB's board of Yangtze-tong A and B village on 29/1/24 is not accepted by the children of Kuike. Therefore, the council is requested to examine the matter. So we wrote to the village council to settle the dispute. This is proper by now. This is absolutely proper. There's nothing wrong with this. The GB's board is not a GB's court. There is no court such as the GB's court. Now, this decision, this complaint of mine, this petition of mine was endorsed to the Bashi's court by the village council. Can you note that, my lord? And you will see at page 36. This is 27/2/2024. This is by the village council. And the typed copy is at page 37. The translated copy is at page 38. With the head DB's court Seochung Nagaland, transfer of case. With due respect and with reference to the above cited subject, it is stated as under the decision of the dispute between Kukike and Shoy Ho regarding the chieftainship of the village was not accepted by the children of Kukike, and therefore it is transferred to the Dubashi's court. So the village council, instead of deciding my case, transferred it to the Dubashi's court. So this is where the problem arises. Now the Dubashi's court, they passed a settlement which is at page 39. 16 April 2004. And the English translation is at page 46.
Yes.
At page 46. And by this decision, the Dubashi's court held in favor of the private respondents. That they are the ones who settle first, effectively means they are the ones who established the SEMA category. This is the meaning of the decision panel. Now, if your lordship may come to the rules are very important.
Yes.
At page 27. Civil justice, is your lordship of that?
Yes.
Rule 23. The administration of civil justice in the state of Nagaland is entrusted to the Deputy Commissioner, Additional Deputy Commissioner, Assistant to the Deputy Commissioner. Customary courts constituted under Chapter 4A of the rules. We don't have this right now. Chapter 4A is not in operation right now, Your Lordship. Then, the Bashis and other village authority may be appointed by the state government from time to time by notification in the official gazette. So, other village authority is only the village council. No one else, my lord. Now, this is with regard to administration of justice in the villages. Now, Rule 23A at page 28. At page 28. The Lordship got that? 23A. The Bashis henceforward shall try and decide such civil cases only as may be referred to them by the Deputy Commissioner or Additional Deputy Commissioner or Assistant to the Deputy Commissioner as the case may be. So who can refer the case to the Dubashis? Deputy Commissioner, Additional Deputy Commissioner, or Assistant Deputy Commissioner? Not the Village Council. Village Council has no authority in law to refer any dispute to the Dubashis without jurisdiction.
Okay.
Without jurisdiction. And so this is what has been upheld, Your Lordship. Firstly, the GB's court is not a court. Against that, I have submitted a complaint, a petition to the Village Council court. Instead of deciding my complaint, the Village Council endorsed it to the Dubashi. The Dubashi, under the rules, had no jurisdiction to take up the issue, the dispute between me and the response. That is my case, my lord. And the decision at page 50. Can we come to that, my lord? Next page.
Page number 20?
Page 50, my lord.
50.
Yes.
Yes.
May I read?
It's just operative part.
My lord, then the lordship may come to Your Lordship, come to page page 56.
Yes.
Many other issues were taken up in this case. Your Lordship, primarily the issue was that the Dubashi's court is not an appellate court. Because what was the practice, what was being followed was the Village Council's decision was being referred to the Dubashi's court, and the Dubashi's court was more or less sitting in appeal. So upon examination of the issue, this honorable court came to the conclusion that the Dubashi's court is not an appellate court and cannot hear any decision against the decision of the Village Council. That was one of the points. And at page 56, at the Lordship, page 56, paragraph D. Rule 23A of the rules is only a supervisory power invested upon the Deputy Commissioner, Additional Deputy Commissioner, Assistant Deputy Commissioner to refer cases to the Dubashi, but is not referable to matters of appeal. So basically, that is the point, Your Lordship. The Dubashis can hear only those matters which are entrusted to them by the Deputy Commissioner, Additional Deputy Commissioner, or Assistant Deputy Commissioner. They cannot take up any matter by themselves. So order they cannot take up.
Not by the Village Council.
Not by the Village Council. Not by the Village Council. The language of Rule 23A itself is very clear. Yeah. So this is a decision. And it's another case. In a nutshell, that is my case. This is about the Dubashis, and I have a list of authorities. Short points, meaning. I'll just cut out the principles, no need to go to the books, my lords. The first one is 2022, 3 GLT 179, paragraphs 12, 13, 18, 20, 23, and 24. 1. Decree or an order passed by court without jurisdiction is a nullity and can be challenged at any stage, even at a stage of execution or in collateral proceedings. Dubashis are not empowered to act as appellate courts. Dubashis can hear only those cases endorsed to them by the DC and or the Assistant Deputy Commissioner. If an order passed by court is bad for out of jurisdiction, all proceedings are void and non-essent law. Then, 2, my lords. 2011 10 SCC 543, an order passed without jurisdiction is a nullity. It does not operate as res judicata, even if such orders attain finality in favor of some party by virtue of not being appealed against. 3, 2009, 3 SCC, paragraphs 19 to 26. An order passed without jurisdiction would be a nullity. It will be coram non juris, not before a judge. Going back to the GB's court also, Imam. not before a judge, it is non-est in the eye of the law. 4, 2010 9 SCC 437. Jurisdiction cannot be conferred on a court, tribunal, authority except through legislation. The same cannot be conferred either by the court or by the consent of the parties. An order passed without jurisdiction is a nullity and will remain unenforceable and inexecutable. So the parties, Your Lordship, going back to the GP's court, the argument we raised that we presented ourselves before GP's court. Parties by consent cannot confer jurisdiction where there is no jurisdiction. Even before the Dubashi's court, parties by consent cannot confer jurisdiction where there is no jurisdiction. Then 5, my lord, 2020, 13 SSC 308. One of the well-recognized exceptions to the self-imposed restraint of the High Court in cases where a statutory alternative remedy of appeal is available is lack of jurisdiction on the part of a statutory quasi-judicial authority against whose judicial order is sought. The question is not whether an authority made the wrong decision, but whether it inquired into and made a decision in which it had no right to consider. A tribunal, which is a creature of a statute, cannot be clothed with a jurisdiction by any concession made by a party. On the same point, my lord, a tribunal exercising a jurisdiction not vested in law is coram non judice, not a court. Not a court, my lord. So, again, one of the grounds taken by other side is that since it is an order of the Dubashi, you can go and appeal to the deputy commissioner. No, that's not the case. The Dubashi court had no jurisdiction to take up the dispute in the first place. So this argument about a statutory appeal being available, that is also without any basis. This is the point which I'm trying to make. Dubashi's court, no authority to adjudicate. Therefore, to say that I have an alternative remedy to file an appeal before the commissioner, deputy commissioner, that is also an argument without any basis. And another point which the other side is taking is that these are decisions which have been taken years back. The point of the matter is an order without jurisdiction is a nullity. It can be challenged at any time. That is the point the authorities which I am relying on. On the ground of delay. On the ground of delay. But an order of jurisdiction does not become with jurisdiction because of the past. That is a proposition unknown to law. That is my case. So what I want now, my lord, what I'm asking for in my red petition is that in my petition under 227 is quashing and setting aside of the GB's board. It is not a court. The GB is an authority under the rules. The GB is an authority under the rules. But it is not a judicial court. So I am asking for setting aside, I am praying for setting aside of the settlement dated 29/1/24 of the GB's board, which is NHSC, which is the C to the petition, and the settlement dated 16/4/24, 2004, which is by the Dubashi's court, which is NHF. NHF. And Your Lordship, so far as the dispute between me and the private respondents is concerned, Your Lordship, what I am saying in my petition is that I want these orders to be set aside so that either me or the other parties can approach the appropriate forum to have the disputes resolved. That is my case. And just to show, my lord, that in terms of the rules, the only authority in the village is the village council, which can act as a court. It has always been there, but the amendment of 2002 has made it more clear. And Your Lordship, at page 16, internal page 16, has Your Lordship got it? It's in the second page, third page. The amendment to section 14. Third page. Your Lordship got it?
Yes.
Section 14 of the Principal Act with title Administration of Justice, deleted by Nagaland Area Amendment Act of 1985, shall be reinserted as under Administration of Justice. 14.1. The village council shall function as a village court as envisaged under the Administration of Justice and Police in Nagaland 1937 as amended, and administer justice within the village limits in accordance with the customary law and usages as accepted by the canons of justice established in Nagaland, and the law in this respect is enforced from time to time. Further, any appeal against a decision of the village court shall lie with the subordinate district customary court and district customary court as decided by the area administrative office or the deputy commission. The last part, the appellate provision, that is not there. We still don't have the district customary court. That we don't have. But the fact of the matter is, this rule makes it very clear. Amendment to this rule makes it very clear that in the village council, no, in the villages, as laid down in the Rules of Administration of Justice and Police in 1937, the village court, the village council court is the only court, no other court. So I just wanted to place that for clarification. That is my case.
First thing first, Lordship, can you come with the prayer portion, which my learned friend has referred to? Page 15 of the writ petition. By approaching this honorable court, what do you want? Can you see the prayers quashed and set aside? A. The settlement dated 29/1/2004 passed by the GB Sport, Yangzitung A and Yangzitung B village. This is an order passed on 29/1/2004. We are in 2026 now. And the writ petition was filed only in 2023. Second prayer. The settlement dated 16/4/2004 passed by the TB's court, Siochong. This is also 16/4/2004. And this order is an order passed on the basing on an application which was submitted by the present petitioner. Since they did not object to the order passed by the GB Sport, they have filed a complaint to the GB Sport. And since they have already passed the order, and an order passed by them, they have to rehear it. So no, we do not have the power. We have already passed the order. So it was referred to the Tobashi's court, TB's court, in short. Not that an appeal was filed before the TB's court, but it was referred by the TB's court to TB's court for adjudication. And both the orders are of 2004. And the writ petition was filed in 2023. So there is delay in laches on the part of the petitioner. If at all they are aggrieved by any of the orders, they could have taken appropriate steps at appropriate time. But there is serious delay in laches where this honorable court cannot interfere in such actions. And kindly come to prayer B, page 16. Permit the petitioners and or any aggrieved party to take appropriate steps before a court of competent jurisdiction to adjudicate and settle a dispute to chieftainship in Yangzitung B, Kuki village. So the object of approaching this honorable court is to issue a direction by this honorable court to take appropriate steps before a court of competent jurisdiction. Now, they are seeking a competent jurisdiction to file a case. If at all they want to file a fresh suit in a competent court, who has stopped the petitioner to file such a suit? Nobody has stopped them. So it is open for them even now to file, but not under direction issued by this Honorable Court. Because if this Honorable Court at this present stage pass an order directing or for that matter allowing the petitioner to file a writ petition to file a suit, they can take their refuge in the order passed by the Honorable Court that look, Honorable Court has permitted us, allowed us to file a suit. Therefore, there is no question of delay. So all our contention will go there. So if at all they want to file a suit, it is open for them. In a competent jurisdiction, they can file, but not under direction and order of this Honorable Court. It was open for them for the last 20 years, more than 20 years. Why they have not filed? Therefore, approaching this Honorable Court is only with a motive to cover up the delay and breaches committed by the petitioners. Therefore, the present writ petition is not maintainable at all on the ground of delay and breaches, and no order may be passed or no direction may be passed by this Honorable Court allowing them to file a civil suit or to approach any competent. It is open. Nobody has stopped them. It was open for them for the last more than 20 years. They have not availed that. And coming before this Honorable Court, just in order to cover up the delay in breaches on the part of the petition. Now, when we come to page 38 of the writ petition, this is the document. Page 38, this is the translated copy of the reference. Office of the Yangzidong A and B Village Council, PO so and so, so and so. To HT, that means Hit Tobashi, and DB's Court, Siochung, Nagaland. Transfer of case. With due respect and with reference to the above referred subject, it is stated as under the decision of the dispute between Kokie and Shoiho regarding the chieftainship of the village was not accepted by the children of Kokie, that is the petitioners, and therefore it is transferred to the DB's court. Now, in view of this, the DB's court has exercised the jurisdiction, and it is the petitioner who have not accepted the judgment. So they file a complaint that no, we are not accepting this judgment, so kindly again see to it. And it was referred to the DB's court. For the DB's court in 2004, they appeared. The petitioners appeared before the DB's court without any complaint. And they participated in the proceeding in 2004. And having participated in the proceeding in 2004, now they are coming with a plea that, oh, DB's court do not have the jurisdiction to try the case. Therefore, we should be allowed to file approach an appropriate forum. Now, if I want to cover up something, in that case, if we are to accept the contention of the petitioners that if an adverse order is passed against me, and agree by that, I approach a wrong forum. I approach a wrong forum, knowing fully well that the forum do not have the jurisdiction. I just approach. And then order was passed. Now, can I be permitted to come now and say that, look, you do not have the jurisdiction to try the case, so it should be interfered, and I should be allowed to file approach an appropriate competent court of law. Can that be, Lordship? That is how the petitioners are approaching and filing this present writ petition with this motive. So they are stopped. They have admitted to the jurisdiction of the DB's court now. when the matter was referred to the DB's court, they have accepted that and then admitted to the jurisdiction. Now, they are stopped to raise and question that. And what prevented them to question that at that relevant point of time? If they do not have the jurisdiction. And one aspect of the matter which we should be clear on, one point, Lordship, that is, nobody has filed any appeal before TV's court. The learned additional advocate general, by referring to page 50 of the writ petition, where the Honorable Justice Kohima has passed an order in one of the civil cases, there the decision was, the ratio laid down in that case was with regard to the powers of the appellate court, whether the Vice court can sit as an appellate court or not. That was the issue. Against the order passed by the village council. This honorable court says that no, the Vice court cannot. That was a case where there was an appeal before the Vice court, TV's court. Here is a case I have referred to page 38. How and who has filed an appeal? Nobody has filed an appeal before the TV's court. It was only referred by the TV's court to the TV's court. Nobody has filed an appeal. But the ratio laid down in the other case, which the learned additional advocate general has relied upon, which was also supported by the counsel for the petitioner, is with regard to a dispute about the appeal filed before the TV's court against the order passed by the village council. So this honorable court said that no, TV's court do not have the power to entertain an appeal against the order passed by village council court. But as I have submitted, Lordship, in our case, nobody has filed an appeal. And if so, what is the appeal number? As I have referred to your Lordship at page 38, it was only referred to the DB's court, and DB's has taken up the case, and the petitioner has already submitted to the jurisdiction. And now they are coming with a plea that no, the DB's court do not have the jurisdiction. Now again, can we come to page 48? This is the order passed by the DB's court. So this will support what happens happening, Lordship, whether it is appeal and who has referred the case. DB's court has decided the case only under reference by the village council. It is not an appeal. Therefore, the contention of the learned additional advocate general as well as the petitioners is irrelevant so as to decide this particular case. Lordship, can we come to paragraph 15 of my affidavit? There I have referred about the rules, rule 24.
Page number?
Paragraph 15, page 14 of affidavit in opposition. Delay and laches I have mentioned in paragraph 14 and 18. And then in paragraph 11, I have mentioned about this is to unsettle a settled matter. In paragraph 11, I have mentioned that. And delay and laches I have stated in paragraph 14 and 18. And can we come to paragraph 15? that with regard to the statements made in paragraph 18, the deponent denies and further submits that the petitioner's contention on GB Sport not being a court contemplated by the rules of 1937 is baseless. It is pertinent to mention that Rule 24 of the rules of 1937 clearly stipulates that Mazadars, Kaunguras, chiefs, headmen of kills, Tobashis, or other village authorities sitting with the village elders in council are empowered to try cases without limit as to amount, but with the following reservations. A. They may not try suits in which a native of the plains or native of another village, no resident in the jurisdiction, the party, and all suits be decided in open tower in the presence of the parties and at least 3 respectable witnesses. In this particular case, all the parties were present. As such, the contention advanced by the petitioners that the settlement dated 29/1/2024 is without jurisdiction, nonetheless, and void of initial is without basis. Therefore, the GB Sport has rightly exercised its jurisdiction within its jurisdiction. And then can they come to paragraph 19 and 21? Here I have stated about the delay and latches and the structure. Paragraph 19. I'm reading Lordship, paragraph 19. That with regard to the statements made in paragraph 22, the deponent denies and reiterates the proceeding paragraphs 14 to 17 of this affidavit in opposition. The deponent further states that the settlement order dated 29/1/2004 and the settlement dated 16/4/2004 have been conducted without any biasness after hearing all the parties at the time of disposal, and as such, the contention advanced by the petitioners as the settlement orders being violative of Part 3 of the Constitution of India is nothing but a vague statement. And paragraph 21. Paragraph 21. That with regard to the statements made in paragraph 24 of the petition, the answering deponent denies and further states that the matter pertains to a 20-year-old case, which does not merit the attention and them of the court, as the villagers are also satisfied with the above settlements, which are in conformity with the historical reality and have accepted it wholeheartedly. Moreover, for fears of undergoing customary oath taking, the petitioners have already consented to the judgment of the DB's COCHO by appending their signatures. In the judgment passed by the DB's court, they have appended their signatures. And if you are not willing to accept this, then let us go for customary oath taking. They have declined to do that. Maybe fear of retribution. Further, the above settlement could not be acted upon by the respondent because Yangzitong A and B village has only one village council and one VTB. VTB means Village Development Board. And unless they are separated, Yangzitong P cannot have separate village chief, and for which initiatives are being taken but not yet realized. Therefore, the dispute of chieftainship between the petitioner and the respondent does not arise, as the villagers as a whole have agreed and accepted Shoiho's descendants to be the rightful claimant to chieftainship at Yangzitong P, Shoiho village. Shoiho is the respondent's party. Now, on the ground of delay and latches, I will cite only one judgment, and I will refer to 3 paragraphs only. Paragraph 12, 13, and 14. And this is a citation of 2024. Here, I'm citing only one because this is a recent judgment where many judgment has been referred to and relied upon. 2024, 15 SSC 215. Paragraph 12, 13, and 14. Only 3 paragraphs I will refer to. Paragraph 12. What you will find at page 221. This court in Treaty Kumar Genital versus State of West Bengal has held to the following issue. We are unable to uphold the contention, it is no doubt true that there can be no waiver of fundamental right. But while exercising discretionary jurisdiction under Article 32, 226, 227, this is a petition under 227 or 136 of the Constitution, this court takes into account certain factors, and one of such consideration is delay in laches on the part of the applicant in approaching a writ court. It is well settled that power to issue a writ is discretionary. One of the grounds for refusing relief under Article 32 or 226 of the Constitution is that the petitioner is guilty of delay in laches. If the petitioner wants to invoke jurisdiction of a writ court, he should come to the court at the earliest reasonable possible opportunity. Inordinate delay in making the motion for a writ will indeed be a good ground for refusing to exercise such discretionary jurisdiction. The underlying object of this principle is not to encourage agitation for stale claims and exhumed matters which have already been disposed of or settled, or where the rights of the third parties have accrued in the meanwhile. In the case of some cases have been referred, I'm skipping that. 58. There is no upper limit and there is no lower limit as to when a person can approach a court. The question is of discretion and has to be decided on the basis of facts before the court, depending on and varying from case to case. It will depend upon what the breach of fundamental right and the remedy claim are, and when and how the delay arose. So in our case, 2004 is the claim made by the petitioner. 13. It is opposite to take note of the dictate laid down by this court in so and so, wherever it has been held that the High Court may refuse to exercise extraordinary jurisdiction if there is negligence or omission on the part of the applicant to assert his right. It has been further held thereunder. Delay or laches is one of the factors which is to be borne in mind by the High Court when they exercise their discretionary powers under Article 226 of the Constitution. In an appropriate case, the High Court may refuse to invoke its extraordinary powers if there is such negligence or omission on the part of the applicant to assert his right as taken in the conjunction with the lapse of time and other circumstances causes prejudice to the opposite party. Even where fundamental right is involved, the matter is still within the discretion of the court, as pointed out in Durga Prasad versus Controller of Imports and Exports. Of course, the discretion has to be exercised judicially and reasonably. 7. What was stated in this regard by Sri so many cases are referred. I'm skipping that. Now, the doctrine of laches of courts of equity is not an arbitrary or a technical doctrine, where it would be practically unjust to give a remedy either because the party has, by his conduct, done that which might fairly be regarded as equivalent to a waiver of it, or where, by his conduct and negligence, he has sought perhaps not waiving the remedy, yet put the other party in a situation in which it would not be reasonable to place him if the remedy were afterwards to be asserted. In either of the cases, lapses of time and delay are most material, but in every case, if an argument against relief, which otherwise would be just, is founded upon mere delay, the delay, of course, not amounting to a bar by any statute of limitation, the validity of that defense must be tried upon principles substantially equitable. Two circumstances always important in such cases are the length of the delay and the nature of the acts done during the interval, which might affect either party and cause a balance of justice or injustice in taking the one course or the other. As far as it relates to the remedy, it would be appropriate to note certain decision of this court in which this aspect has been dealt with in relation to Article 32 of the Constitution. It is apparent that what has been stated as regards the article would apply a fortiori to Article 226, it was observed in so and so that no relief can be given to the petitioner who, without any reasonable explanation, approaches this court under Article 32 after inordinate delay. It was stated that although Article 32 is itself guaranteed right, it does not follow from this that it was the intention of the constitution makers that this court should disregard all principles and grant relief in petitions filed after inordinate delay. It was stated in State of MP versus Nandal Teswal that High Court in exercise of its discretion does not ordinarily assail the dirty and the indolent or the acquiescence and the detergent. If there is an alternate delay on the part of the petitioner and such delay is not satisfactorily explained, the High Court may decline to interfere the grant relief in exercise of its rich jurisdiction. It was stated that this rule is premised on a number of factors. The High Court does not ordinarily permit a belated resort to the extraordinary remedy because it is likely to cause confusion and public inconveniences and bring in its train new injustice. And if rich jurisdiction is exercised after unreasonable delay, it may have the effect of inflicting not only hardship and inconveniences, but also injustice on third parties. It was pointed out that when writ jurisdiction is invoked, unexplained delay coupled with the creation of third-party right in the meantime is a modern factor, which also works with the High Courts in deciding whether or not to exercise such jurisdiction. Paragraph 14. This is the last paragraph I'm referring. Reiterating the aspects of delay and latches, it is entitled the discretionary relief being granted this court in so and so. I'm skipping that. Thus, the doctrine of delay and latches should not be lightly brushed aside. A writ court is required to weigh the explanation offered and the acceptability of the same. The court should bear in mind that it is exercising an extraordinary and equitable jurisdiction. As a constitutional court, it has a duty to protect the rights of the citizens, but simultaneously, it is to keep itself alive to the primary principles that when an aggrieved person without adequate person approaches the court at his own leisure or pleasure, the court would be under legal obligation to scrutinize whether the lies at a belated stage should be entertained or not. Be it noted, delay comes in the way of equity. In certain circumstances, delay and latches may not be fatal, but in most circumstances, inordinate delay would only invite disaster for the litigant who knocks at the door of the court. Delay reflects inactivity and inaction on the part of a litigant. A litigant who is forgotten the basic norms, namely procrastination, is the greatest thief of time. The second, law does not permit one to sleep and rise like a phoenix. Delay does not bring in hazard and cause injury to the lease. So this is the law laid down by the FX court. So many rulings have been referred to. There, it should not be taken lightly. And our case is more than a 20 years case, where this honorable court should not ignore the delay on the part of the petitioners. More particularly when they are questioning the jurisdiction, it was known to them and they have admitted to the court. My learned friend has made the submission that Chapter 4A of the rules has not been enforced. So whether enforced or not, by the notification of the government on 16 April 2025, by amendment, by the 5th Amendment Rules 2025, the customary courts, 3 tiers, village court, sub-divisional court, and the district customary courts has been constituted by the government and enforced. Chapter 4A. My learned friend has made a submission that it is not enforced. It is enforced by the act of the legislature. And chapter 4A, Rule 39, Lordship will find, and then how the court should function. All these are shown under Rule 40, 41, 42, and 43. So the petition do not have any merit, and the writ petition is labeled with dismiss, with cause for wasting the precious time of this honorable court.
Much obliged. Few short points in reply. First of all, the respondents are not permitted to have the cake and eat it too, as the saying goes by the truism. Now, if your lordship will see paragraph 15, which my learned friend was referring to, paragraph 15. In their affidavit, they are saying the GP's code is a code. Paragraph 15, which my learned friend is referring to. Then in that case, going by Rule 23A, the simple reading of Rule 23A, the Vice's court has got no appellate jurisdiction. They cannot decide this case. They cannot sit and appeal over this. By their own argument. But what I am saying is this: yes, the GP is an authority, but the GP is not a court. And therefore, I submitted a complaint to the village council, and your lordship will see, just to see the language again, one more time, at page 36. At page 36. Page 6 is the original, and page 38 is a translated copy. No. Page 34. Page 35, page 33 is the original, and page 35. This is addressed to the village council. It is not addressed to the Vice's court, my lord. It is addressed to the village council. I am saying I do not accept the decision of the GB, and therefore my case should be decided. I have addressed it to the village council, not the Dubashis. What did the village council do? The village council by 36 endorsed it to the Dubashi court. Not by me. The village council, instead of deciding the matter, endorsed it to the Dubashi court. So according to Rule 23, only the deputy commissioner, the additional deputy commissioner, and the assistant deputy commissioner can endorse cases to the Dubashi. Only the deputy commissioner. We're not talking about appeals alone. Any matter for the Dubashis to decide can be endorsed to them only by the deputy commissioner, additional deputy commissioner, and assistant deputy commissioner. And read into it by the Honorable Court is that the Dubashis court does not have any appellate power. Now, my lordship, in paragraph 7 of my writ petition, in paragraph 7 and 8, paragraph 7 and 8, I have said that from the inception of the village, from 1878, my ancestor has been the chief of the Semakia, and that continues till date. Till date. The fact that they have their own narrative now, it's a different matter. Now, why I am saying this, regardless of the decision in 2004, regardless of the decision in 2004, they have not been able to do anything. Because effectively, what the decision of 2004, the Vice's court decision of 2004 says is, they are the persons who came to the village first, which means they are entitled to the line of chieftainship. That is the import of the decision of the Vice's court. But that decision of the Vice's court has not been given effect to till date. Only recently, madam, this problem has cropped up again. And that is why I came before this court. Only recently. And if you will see paragraph at next page at paragraph 8. May I read this paragraph, madam? That in 1954, Sahoy Yoptami, the chief, that is my ancestor, allowed Ruhoko Yoptami, the son of Shoiho Yoptami, ancestor of the other side, to take on the position of assistant chieftainship. Now, your lordship, I admitted him into assistant chieftainship. After his death, he was succeeded by Kakia Yaptami. Kakia was succeeded by Kotoi Yaptami. Kotoi was succeeded by Hujeta Yaptami. The assistant chieftainship is now being held by Kotoi's son Kehodo Yaptami. The succession is within the lineage of Shoiho Yaptami. So what is happening now, my lord, is that the subordinate is trying to take the position of the superior. That is not permissible in semi-customary. It is not permissible. And so, notwithstanding the order of the Debashis Court in the year 2004, it has not been given effect to. It has not been given effect to. And what is the import of the Debashis Court? What does the Debashis Court say? That Shoiho Yaptami was the first to come to the village. No decision, no actions has been taken by the other side on that so-called decision. But the fact of the matter is, the Debashis Court had no authority in law to decide the dispute between me and the private respondents. The consent of the parties does not confer jurisdiction. An order without jurisdiction is non-est in the eye of law, my lord. An order which is non-est in the eye of law does not become within jurisdiction due to the passage of time. It can be challenged at any time, even at the time of execution. And till today, it has not been executed. Any order, your lordship, any order which is being passed must be executed. Even the decision of the village council and the Debashis Court has to be executed. Your lordship may kindly know. It must be executed. The rules are very clear. If the parties do not execute, the order is as good as dead. But that is besides the point. That is not the point of execution. An order without jurisdiction is not est. And a non-est order does not become within jurisdiction due to the passage of time. And the authorities relied upon by my learned friend also says delay and lashes do not fit into a straitjacket formula. It depends on the facts and circumstances of each case. And not only that, the last point, it would appear as though I'm trying to mislead this honorable court now. The last notification which my learned friend has placed, saying that the district customary courts have been created, wrong. Lordship may kindly come to the second page. Second page. An attempt has been made to create, Lordship, it's very unfortunate. In the state of Nagaland, an attempt has been made to create so-called customary courts exclusively under the control of the state government. There's some discussion going on this point. Now, your lordship will come to section 2, section 1, short title and commencement. It shall come, subclause 2, the lordship quoted. It shall come into force on such date as the state government may by notification from the official gazette appoint. Notifying it is one thing, but enforcing it is by another notification, not notifying. It has not been notified.
So gazette notification has not been made.
The date of enforcement has not been notified. The rules have been notified. But the enforcement, which is to come about by another notification in terms of 1.1.2, that notification is yet to be announced. It is yet to be notified. So the amendment creating the district customary courts is yet to come into force.
Okay. We reserve the judgment.
Yes, ma'am. Much obliged for a very patient hearing.
Any other? Yes.
For orders, item number 17.
Mr. Ejimone, learned counsel for the petition. And Mr. I.M. Song, learned additional legend for the respondent number. Im Song was for respondent number
1, the state respondents for 1.
respondent number 1, and Mr. Citizen, learned senior counsel assisted by Mr. learned counsel for the respondent number
2 and 3.
2 and 3. Argument concluded, judgment reserved.
May I please, my lord? Your lordship, here in this case, I was trying to take steps upon respondent 6 to registered 18. And then on 13/10/2025, have taken steps, and then as of now, notice is still awaited.
So we'll wait for the report.
Lordship.
After 2 weeks or 3 weeks?
3 weeks, Lordship.
After 3 weeks. Heard Mr. Walling, learned counsel for the petitioner. Office note dated 4/12/2025 and 12/1/2026 indicates that service report in respect of respondent number 6 is still awaited. List the matter after 3 weeks, awaiting service report upon the respondent number 6. None appears for in respect of other respondents.
Respondent 1 to 5, the government.
Okay, none appears for the respondent number 1 to 5. List the matter after 3 weeks.
Lordship, there's an interim, Lordship.
Interim order passed earlier shall continue.
For orders, item number 19.
Mr. Angami, you are appearing in this matter? Yes. Okay. Letter on Mr. Angami entered appearance for the respondent number 1 to 5 and 7. Okay.
My lord.
Yes.
My lord. Here in item 19, service upon respondent 4 is still awaited.
Your Lordship, if I may, this is again similar to the previous matter. Again,
Okay.
similar. So now the village council decided the matter, and I was not satisfied with the order of the village council. I appealed to the deputy commissioner.
Mm.
The deputy commissioner endorsed it to the Dubashi's court.
Mm.
And so therefore, my lord, that process was wrong. The Dubashi's court passed a settlement. That settlement is bad. They have challenged that. I agree that that order is bad. So in this case, instead of keeping the matter pending, my lord, the settlement of the Dubashi's court can be set aside, and the DC may be directed to hear the appeal.
Okay.
The respondent number 4 is the village council. Village council may not be necessary here, man. Village council is the court at the village level.
Mm.
They passed an order. I was unsatisfied,
Mm.
dissatisfied with the order. I filed an appeal to deputy commissioner. Deputy commissioner endorsed it to Dubashi's court.
Mm.
They have come to Village Zone court because they are against the Dubashi court's order. I agree. Dubashi's court order is bad.
Mm.
Then the Dubashi's court order be set aside. The appeal which I have filed, let it be decided by the deputy commissioner.
Mm.
Short matter, madam. No need to keep it pending.
So we will remand the matter to the
Deputy
DC.
commissioner, yes.
Okay. DC of who is this?
Dimapur. DC of Dimapur.
Dimapur. Okay.
Worship, in that case, if till the matter is heard before DC, if the interim may be continued.
So order is set aside.
Yeah.
If the order is set aside, it goes. Once the
No,
order of the
if we today set aside the order,
Yes.
then
Lordship, yes.
Yes.
Understood, Lordship. Yes.
any other matter?
No.
Okay.
Vice Lord.
Right.